Minister of Manpower.
Mr. Deputy Speaker, I would like to thank all 17 members who have spoken in support of the bill. It has been quite a marathon because I took the stand at about 4 p.m. So it was about 3 hours ago. Every one of you have raised important issues which I will address. But in the interest of time, and also in support of Ms. Anthea Ong's very timely reminder of the importance of mental well-being, I seek members' kind understanding that I will focus on points relating to today's amendments, and there are about 40 pages of it. The other points, of which I have about 20 pages of, are of course very important, but I think they can also be addressed on other occasions, or if we have some time later. As we debate the merits of the proposals, it is useful to remember the wise words of Mr. S. Rajaratnam when he presented the Employment Act Bill to Parliament in July 1968. It's a very uncanny coincidence, but that was also the month I was born. He said, the employment bill should therefore be seen in the context of the new problems an independent Singapore faces. There must be a climate of industrial peace and stability to attract both local and foreign capital. It is essential to increase the productivity of our workers, the efficiency of entrepreneurs, so that our products can compete in the stiff, competitive export markets of the world. That is the intent and purpose behind this bill. And how far this bill will succeed in its purpose will depend on both workers and employers placing national interests before sectional interests. Close quote. So although 5 decades has since passed, the fundamentals have not changed. The EA exists to regulate employment practices in a balanced way, protecting workers while retaining labour market flexibility for businesses to thrive and create good jobs. A few more points are worth remembering. First, the EA is our main, but not the only employment-related legislation. It works in concert with other important pieces of legislation, such as the Workplace Safety and Health Act, the Work Injury Compensation Act, the Retirement and Re-employment Act, the Employment of Foreign Manpower Act, and all these are to advance the interests of our workers. Third point, besides laws, our unique brand of tripartism also relies on tripartite guidelines, standards and advisories to promote fair and progressive practices while ensuring good employment outcomes. Third, in everything we do, tripartite partners strive to be pro-worker and pro-business. This has been a cornerstone guiding employment practices in Singapore that has served us well. Fourth, in recent years, employers have been asked to take on more obligations, such as longer paternity leave and re-employment of older workers, first to 65, then to 67. As we debate EA changes, bear in mind also that tripartite partners are always in an ongoing conversation about other areas that may see further changes in the coming years. Fifth, the government also plays its part for local workers. In the provision of healthcare, for example, the employer's major contribution is through the CPF, which builds up our MediSave. The government's efforts include the development of public healthcare facilities and schemes like MediShield Life, CareShield Life and CHAS, which together keep healthcare affordable without placing excessive burdens on individuals and employers. So I hope, members, we can keep these points in mind as I address your specific concerns. Let me start with the coverage of the EA and whether we can up the provisions, make them more generous. Mr. Melvin Yong asked for the distinction between workmen, non-workmen, and managers and executives to be removed. The tripartite partners discussed this extensively. At workplaces, the lines between workmen, non-workmen, managers, and executives are indeed blurring. In the Employment Act, the distinction remains largely in Part 4. Among other things, Part 4 regulates working hours, rest days, and overtime payments, including the more than 700,000 managers and executives whose work are much more varied and tend to be more outcome-based, will make our laws much more rigid and prescriptive. To Mr. Dennis Tan's point on defining managers and executives, given that employment practices evolve constantly, the current approach of referring to managers and executives as those employed in a managerial or executive position while taking reference from case law works well for the tripartite partners. In a High Court ruling earlier this year, it was also made clear that the actual work requirements and individual circumstances matter more than the job title given. So there are already some parameters we work within, and they generally work well. Within Part 4, the coverage for workmen and non-workmen have been different since the EA was first enacted in 1968. Workmen who are manual workers generally need more protection where overtime is concerned. This remains so today. The salary threshold of $4,500 therefore covers nearly all workmen, whereas the salary threshold for non-workmen cover about half of them. Mr. Zainal Sapari, Mr. Saktiandi Supat, Mr. Gantiam Po, Mr. Arasu Duresami, and Associate Professor Daniel Goh asked if the salary threshold for non-workmen could be higher or even removed completely. Our longer-term intent is indeed to close the gap between the salary threshold of workmen and non-workmen. That said, in every EA amendment, tripartite partners consider carefully the impact on both workers and employers. When benefits are upped, so too are the costs borne by employers. Indeed, former nominated Member of Parliament, Associate Professor Randolph Tan, wrote an op-ed expressing some concern about the timing of this round of EA enhancements, whether businesses could absorb the impact in the current economic climate. Mr. Douglas Foo also pointed this out in his op-ed published in the Straits Times yesterday and earlier when he spoke. Thankfully, in Singapore, our union leaders recognize the need to consider the package of improvements and not just individual items. They know it is equally important to give employers time to adjust to changes that come from many directions, not just the EA. In this amendment, the tripartite partners agreed to the major shift to extend EA core provisions to cover all managers and executives. This already benefits 430,000 managers and executives. The expanded coverage under Part 4 benefits another 100,000 or so workers. And so in total, we're talking about more than 500,000. Tripartite partners are mindful that changes should not inadvertently affect workers' employability. They reached a consensus that these shifts are sufficiently well calibrated and remain committed to review the thresholds in future amendments. Let me now turn to the gig economy, self-employed persons. Mr. Zainal, Mr. Saktiandi, Associate Professor Walter Teixeira, and Ms. Joan Pereira, and also Ms. Denise Phua, raised concerns about protections for self-employed persons, or SEPs. By their very nature, SEPs do not have the same kind of relationship with their service buyers as that between employees and employers. This is the main reason we do not attempt to regulate SEPs' relationship with service providers under the Employment Act. Earlier this year, a tripartite work group formed by the MOM had put forward a set of recommendations to address SEPs' common challenges, some of which were outlined in earlier speeches. And in the earlier circulation of materials, I believe not only the summary of the Employment Act changes were distributed, there was also another separate circular that outlined the recommendations of the tripartite work group. Now, at MOM's COS debate in March, I announced the government's acceptance of the recommendations and our implementation plan. I'm pleased to share that we are making good progress and will update members at a later date. To Associate Professor Walter Teixeira's point, we recognize that workers can indeed be wrongly classified as SEPs to avoid EA obligations. Anyone unsure of his employment status should approach MOM so that an appropriate determination can be made. In the last 3 years, we have successfully intervened in around 100 cases where the employees were wrongly classified as SEPs and helped them to recover their due statutory benefits or CPF contributions. Mischievous employers should take note and realize that they can be prosecuted for non-provision of such salary and benefits. Let me now deal with specific provisions of the EA, starting with rest days. Mr. Zainal and Mr. Melvin Yong suggested double pay for work on a rest day, regardless of who requested for it. There are good reasons for the differentiation. The double rate discourages employers from asking employees to work excessively. On the other hand, the single rate, if workers request to work on rest days, ensures that workers are not inadvertently encouraged to work excessively for the double pay, when actually they should be resting. Mr. Zainal is of course concerned that the employers do not always know that they are due to be paid at the double rate if their employers ask them to work on their rest day. Mr. Yong worries that these workers are forced or deceived into believing false or deceived into declaring these as self-requested. They are valid concerns. MOM is keen to partner NTUC to strengthen outreach for the Work Right initiative to educate employers and employees about their responsibilities and rights. This would also address Ms. Joan Pereira's concerns and raise awareness amongst the employees who have not been paid the right amounts to submit a mediation request to the Tripartite Alliance for Dispute Management. Let me state categorically that if an employer is found to have misrepresented the worker's request to work on a rest day, we will take the employer to task for non-payment of salary or providing false information. Let me now deal with leave entitlements. Dr. Intan asked if the carry-forward provision for unused annual leave can be extended to all employees. Ms. Jessica Tan also asked if an employer is required to pay the employee for unutilized annual leave. To clarify, annual leave provisions in Section 88A used to be in Part 4 and now apply to all employees. However, the employer's obligation to carry forward unutilized annual leave to the next year remains for Part 4 employees only. Tripartite partners decided against extending the carry-forward provision to all employees, which now include higher-earning managers and executives. No more limit. This is out of concern for the otherwise drastic impact on business liabilities. I think members who are familiar with HR practices know that actually you have to set aside the liability and factor it as a cost in your books. So there's a real impact. Annual leave should be planned ahead of time to meet both employee and organizational needs to avoid situations of unconsumed leave entitlements. If the employer is unable to approve leave due to work exigencies and the employee has shown reasonable efforts to adjust his leave plans to suit organizational needs, the employer should allow for leave encashment. This is so that the employee can benefit from his statutory entitlement. To Mr. Saktyandi's question, there is no need for the employer to force the employee to take leave if an employee does not want to utilize his leave entitlements. However, we do encourage workers to take their annual leave to rest and recharge from their work to maintain their mental well-being. That's what the provisions are for. Dr. Intan asked about TCM practitioners. A small number of doctors have dual registration under the Traditional Chinese Medicine Practitioners Act and the Medical Registration Act. For the purposes of granting paid sick leave, employers are required to recognize the MCs issued by such practitioners in their capacity as doctors under the MRA. Now, Ms. Irene Quay asked that we also require employers to recognize the MCs issued by collaborative practice prescribers, or CPPs. Today, as CPPs are not registered under the MRA, the Ministry of Health does not allow them to issue MCs. We understand that MOH will need time to assess the program as well as other new models of care before deciding whether other healthcare professionals can be certified to issue MCs. MOM will therefore continue to monitor these developments and adjust the EA if necessary. Ms. Irene Quay also asked that we encourage employers to allow for up to 3 non-consecutive days of sick leave without MC per year. And she gave many good reasons why this would be a more productive approach. While we recognize the members' call for this to be mandated, Ms. Quay herself also rightly pointed out that employers will need to create controls, surveillance and audit systems to ensure that their employees do not abuse the system. This will inevitably add to business costs. As the EA does not prohibit employers from doing so already, progressive companies are free to go ahead to offer this as part of their talent attraction and retention strategies. A number have done so. We will continue to give them flexibility to decide what works best for them. Mr. Patrick Tay and Mr. Yong asked for clarifications regarding hospitalization leave. Today, employers are not required under the EA to recognize an MC from private doctors, other than their own panel doctors, for purposes of paid sick leave. The amendments to the EA in this bill will require employers to recognize MCs from any doctor, whether private or public, for purposes of granting paid sick leave. To Mr. Tay's question, employers can recognize MCs for purposes of granting hospitalization leave from any doctor in the private hospital. In fact, there is no evidence today that employers have refused to recognize MCs from approved hospitals. We expect that employers will continue to recognize MCs from all approved hospitals. An employee who has chickenpox or other infectious diseases and who is hospitalized or certified by a hospital doctor to be ill enough to be hospitalized will be granted paid hospitalization leave, even if he is not physically warded. For MCs issued by non-hospital doctors, such as general practitioners, employers are required by law to recognize the MC for the purpose of granting paid sick leave up to 14 days. The 14-day entitlement for outpatient medical treatment is sufficient to cover the vast majority of employees today, given that the average number of days of sick leave taken is 4.8 days. Employers are free, of course, to grant additional paid sick leave beyond the annual 14 days entitlement should an employee need it. And we have come across many cases where the employers, out of the goodness of their hearts, extend this when the employees do need it. Turning to clarifications on authorized deductions, Mr. Louis Ng and Mr. Patrick Tay asked about the implementation and safeguards for authorized deductions. To clarify, Section 27(1)(f) remains largely unchanged. As is the case today, employers must provide proper documentation to prove the legitimacy of deductions if they are for the recovery of any advance and loan. To Mr. Tay's comment on the deduction for payment to a cooperative society, this still remains as an authorised deduction under Section 27(1)(j). To the question of whether Section 27(1)(i) is limited by prohibited deductions in other statutes, the answer is yes. This was Mr. Louis Ng's question, I think. Mr. Ng and Mr. Tay asked about written consent. Such consent cannot be a general clause in a contract stating that an employer can make any deduction as and when necessary. Instead, the consent must be given specifically for a particular deduction that the employee has agreed to. Written consent given by an employee under duress will not count as valid consent. The employer must also maintain proper records to substantiate the written consent. An employer who penalizes an employee for withdrawing consent may also be liable to be prosecuted under the EA. Regulations to protect the well-being of employees. Dr. Intan raised the issue of over-inflating salaries declared or clawing back salaries from rank-and-file workers. Our law today already allows us to take action against errant employers in this regard. If the employer falsely declares the salary of a foreign worker to qualify for a higher work pass, the employer can be prosecuted for false declaration under the EFMA, the Employment for Foreign Manpower Act. Such an employer may also be prosecuted under the EA for non-payment of salary if he pays the local or foreign worker a lower salary than what is declared. For example, in the key employment terms or payslips, or in the in-principle approval that was given to the employee. As for salary clawback, clauses being on the rise among Fortune 100 companies, we have not received such complaints from employees, but we will continue to monitor the situation. Ms. Anthea Ong asked why violations under the new Section 139(2) AA are civil contraventions and not offences. To clarify, the Minister has the power to provide that violations of regulations are either criminal offences or civil contraventions. Civil contraventions allow us to treat less severe breaches as non-criminal infringements, which attract a financial penalty. Compared to non-payment of salary, which is a criminal offence, requiring an employee to sign on a blank salary voucher is a less severe breach, which should attract correspondingly less severe penalties. Wrongful dismissal and the compensation framework. Mr. Louis Ng and Mr. Dennis Tan asked for clarification on what constitutes dismissal without just cause or excuse. Associate Professor Dan Goh asked how the tripartite guidelines on wrongful dismissal and factors for determining compensation amounts will interact with the adjudication work of the ECT. The dismissal is without just or sufficient cause if it was on grounds such as discrimination, denial of statutory benefits, and with the intent to punish the employees for exercising his rights. Dismissal because of poor performance, misconduct, and redundancy are not considered wrongful. As I mentioned earlier, wrongful dismissal is not a new provision in the EA, and there are many cases we can draw reference from. MOM will publish a set of tripartite guidelines on wrongful dismissal, which the ECT must take into account. It would not be possible to define all scenarios of what constitutes wrongful dismissal and what does not. Instead, a more feasible approach is to use illustrations and set out principles and parameters that the ECT must take into account when adjudicating cases. An example of what constitutes wrongful dismissal is if an employer dismisses an employee to punish him or her for exercising a right, such as submitting a mediation request to MOM or reporting the company to MOM for an Employment Act offence, even though he or she has performed satisfactorily at work. In the case reported by Dr. Intan, where the employee felt that she had been forced to resign, a claim can still be lodged with the Tripartite Alliance for Dispute Management to investigate if the dismissal was wrongful in any way. If unresolved through mediation, the case can be escalated to the ECT, and the same applies to persons who believe they had been dismissed due to discrimination. Associate Professor Goh and Mr. Dennis Tan also asked if the ECT claim limit would be increased, given that we will be covering highly paid managers and executives. To clarify, for wrongful dismissal claims, there will be a separate claims limit of 20,000 and 30,000 for union-assisted cases, in addition to the claims limit for any salary or benefit owed. So in other words, it can be up to 40,000 up to 60,000 if the two are combined. The claim limits are established as such because the ECT is meant to be an expeditious and affordable channel for resolving disputes. Cases involving higher claim amounts are likely to be more complicated and hence take more time. And workers with claims exceeding these limits can continue to pursue their claims in the higher courts, where it is probably the more appropriate places to do so. There was a question on frivolous claims. Several members asked how the adjudication of wrongful dismissals at the ECT will work. Mr. Douglas Foo asked if there are any measures to prevent frivolous claims of wrongful dismissal. Mr. Dennis Tan spoke about possible abuse of this recourse by disgruntled employees. These are reasonable concerns and that employers generally have, now that more managers and executives are covered. Employees who feel that they have been wrongfully dismissed may first submit a request to the Tripartite Alliance for Dispute Management for mediation. TADEM will do its part to prevent frivolous and unmeritorious cases from proceeding. And every year there will be some. For cases of contractual termination, where the employer has met all his obligations, TADEM will first ensure that there is a case for the employer to answer before contacting the employer to attend mediation. The employee will have to substantiate why he or she thinks that dismissal was wrongful, for example, by citing specific incidents which gave rise to the claim. For cases like the staff who took advantage of staff travel privileges, which Mr. Satyandi mentioned, if the employer has established such abuse, after due inquiry, the employer can dismiss the employee without notice on grounds of misconduct. Mr. Satyandi and Mr. Teo asked what support has been put in place to facilitate the transfer of the adjudication of wrongful dismissal claims from MOM to the ECT. The ECT and TADEM, where compulsory pre-ECT mediation takes place, will be expanding their manpower to meet the new demands. These mediators and investigation officers involved undergo training programs that have been designed to equip them with the relevant skills. Mr. Ng and Associate Professor Thesera asked if adverse inferences may be drawn against employers if they fail to produce documents such as key employment terms and salary slips, and also the employer's past behaviors. The answer is yes. The ECT will be able to do so. The list of employment laws that the ECT can draw adverse inferences from will be specified in a new fourth schedule in the ECA, the Employment Claims Act. As to whether we will consider reversing the burden of proof for salary claims, we are mindful that reversing the burden of proof for such cases may result in opportunistic employees filing frivolous claims, so we won't do so for now. Ms. Tan and Mr. Satyandi asked how the Ministry will be communicating the changes to the public. Actually, I think Ms. Joan Pereira also mentioned this. MOM will be publishing an online guidebook shortly, summarizing the key amendments to the Employment Act, along with how employers should review their existing HR policies to ensure compliance with the Act. We are also working with SNEF, NTUC and other industry partners to hold briefings on the EA amendments over the next few months prior to the implementation on 1st April 2019. Let me now address questions from Ms. Denise Phua and I believe also Mr. Arasu regarding the changing nature of employment. They have asked how the EA will cater to the changing workforce where employees may be mobile or have multiple employers, portfolio workers. As mentioned, we have other tools that complement the EA. The member mentioned the need to better protect outsourced workers who, by the way, are still employed by the outsourced service provider, which has employer obligations towards the employees. Besides the protection already offered to them under the EA, the tripartite standard on employment of term contract employees will help bring about better employment conditions for such workers. The tripartite standard on contracting with self-employed persons also helps to shape norms and ensure the sustainability of the economy of self-employed work. MOM and our tripartite partners will continue to keep a close watch on workplace trends like the ones that were mentioned, and also others, for example, automation and flexible work arrangements, which Mr. Satyandi spoke extensively about. We will continually review the EA to ensure it stays relevant in regulating employment practices in a balanced way, protecting the rights of workers while retaining flexibility in the labour market for businesses to thrive. I would add further that the right approach may require adjustments beyond the EA, which is indeed the reason we aim to strengthen support for SEPs through the recommendations that I circulated. Once again, Sir, I thank members of the House for their support of this bill. I hope I have addressed questions and suggestions related to today's amendments. The other points remain important and can be addressed at other platforms. In conclusion, let me just say that the EA is a living document and a permanent work in progress. For this amendment, tripartite discussions started quite early in the tenure of former Manpower Minister Lim Swee Say. He's seated right there. And is followed through when I took over from him. Members can be certain that as soon as we start to implement today's changes, we will again be looking forward as to what more is needed for the future. And whether the person standing here to pass those next sets of amendments will be me or someone else, who can tell? Building a tripartite consensus on what are the right changes to make and when to make them, which employee groups to focus on in each amendment. All these deliberations take a great amount of time and effort that is often unseen. I might add, it takes a lot of mutual trust between the tripartite partners too. Yet this is also our greatest strength that has ensured improvements are sustainable with no drastic U-turns every now and then, which you see in other countries. One group, one government promises, and the next government comes in and says they are not valid anymore. We have not seen that throughout the course of the Employment Act. This strength is also mentioned by many MPs, notably Mr. Douglas Foo, Mr. Melvin Yong, Mr. Arasu too. As a result, we have helped our businesses to continue providing good jobs and the vast majority of our workers to enjoy good employment outcomes. MOM is deeply grateful to the many stakeholders in the tripartite partnership that have made possible today's changes. They've worked tirelessly to make this a reality. Let us now focus on getting the changes implemented expeditiously and smoothly. With your permission, Mr. Deputy Speaker, sir, I beg to move.
Mr. Patrick Tay, you want to clarify something?
Just 2 points of clarification to the Minister. I thank the Minister for a very long debate. I know it's taking a lot of time, but just 2 points. Firstly, on the enforcement of ECT claims, I hope the Ministry and tripartite partners can look at the enforcement of the ECT judgments so that we have expedient and also speedy resolution and ease of resolution. That's one. Second one is on Section 18A. I mean, I spoke about it, and I hope the tripartite partners will work together to come out with a set of FAQs and guidelines to give greater clarity before the Act is rolled out. Thank you.
Mr. Deputy Speaker, on Section 18A, I can confirm with the member that his request is being looked into, and I think it can be done. His question on the ECT and expeditious settlement, I agree with him. Our objectives are aligned.
Yes, Ms. Jessica Tan.
I thank Minister for the extensive clarifications, but I just do want to ask one more point around retrenchment. While I understand the need to balance both the cost as well as the impact to employees because of the disruption we're seeing in the workplace and the restructuring of businesses, inevitably there will be impact on employees. So have the tripartite partners come to some way of balancing both the cost and the protection for employees.
Mr. Deputy Speaker, I thank Ms. Jessica Tan for the question. It's a very important area, and tripartite partners have had extensive deliberations on this issue. The member, Mr. Arasu, I think articulated the thinking very well, and in fact, in a recent blog post, Mr. Patrick Teo did likewise. But I think it is useful for me to state it for the record. MOM agrees with the tripartite partners on the need to strike a balance and that it would be counterproductive to try and legislate mandatory minimum payouts in the event of retrenchment. From the employee standpoint, any mandated minimum may become a norm even when employers are in a position to pay more, and this would not benefit the workers. From the employer's perspective, if the mandated minimum is too high, then the companies may not be able to afford, and they may end up becoming overburdened at the point in time when that sum of money could affect the remaining workers. So countries like the US and Switzerland also do not mandate retrenchment benefits. So given these considerations, the tripartite partners have issued instead an advisory stipulating the prevailing norms for retrenchment benefits quantum that employers should take into consideration when determining the retrenchment benefits. In addition, since 1st January 2017, employers have been required to notify MOM of retrenchments. This enables Workforce Singapore, the unions and other relevant agencies to help the affected workers find alternative employment. Now, according to our survey last year, around 90% of the establishments which retrenched workers actually paid retrenchment benefit, even though there was no stipulated mandatory payout, of which 70% paid retrenchment benefit that met or exceeded the prevailing norms articulated in the tripartite advisory. So I think that's a situation that is not too bad. Thank you very much.
The question is that the bill be now read a second time. As many as are of their opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
Employment Amendment Bill.
Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of their opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 14 stand part of the bill. As many as are of their opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Clause 15, Minister.
The Deputy Speaker, there are 12 amendments to Clause 15 as indicated in the order paper supplement. As the amendments are related, may I seek your permission to move them together?
Yes, please proceed.
Mr. Speaker, I beg to move amendments 1 to 12, standing in my name as indicated in the order paper supplement. The amendments proposed to Clause 15 improve the language in the law to make clear the intention for Section 89(3) of the Act on Hospitalization to cover the circumstances I had set out in my second reading speech, including quarantine orders, situations where the employee is not an inpatient of a hospital but is ill enough to require hospitalization during that period and further medical treatment for the condition that the employee was hospitalized for after discharge from hospital.
The question is as proposed by the Minister. As many as are of their opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that Clause 15, as amended, stands part of the bill. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that Clauses 16 to 29 stand part of the bill. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Manpower.
Mr. Deputy Speaker, I beg to report that the bill has been considered in committee and agreed to with amendments.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
Employment Amendment Bill.
Deputy Leader.
Deputy Speaker, I beg to move that Parliament do now adjourn to a date to be fixed.
The question is that Parliament do now adjourn to a date to be fixed. As many as are of their opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Order. Order.